Hi, y'all. Welcome to this afternoon's live stream. Normally we go live Monday, Wednesday, and Friday at 7 p.m., but we're doing a bonus. We've just got so much to cover. I can't fit it all in 3. Almost surely somebody is going to get kicked off the Delphi murders case. But is it going to be the attorneys for Richard Allen, the defendant, or the judge? That's what we're going to try to figure out today. We're going to be looking at a transcript that has just been released. So welcome, everybody. I'm glad you're here with us on a Saturday at noon or whatever time it is, your place. Welcome, Rewatch crew, too. In October, there was a secret meeting between the judge and the lawyers in the Delphi murders case. This is the case against Richard Allen. Now, in this, when I say secret, what I mean is that it was in chambers. It was in the judge's office. There was a court reporter there, but it wasn't in public. The public wasn't invited. In fact, the public was sitting outside waiting for a hearing in the case. But this meeting was separate. But as I said, there was a court reporter there. Now, in the main case, there is a murder case against a man named Richard Allen. He's accused of murdering 2 young teens. He says he was framed. But there's also a second case. There is a case within the case. And this second case is a battle between the judge and Richard Allen's lawyers, Brad Rosie and Andy Baldwin. And even though it sounds insane and even impossible, there's actually an arrest and a dead body in that second case as well, even though that sounds crazy. We'll talk about all of this. In the hearing that we're going to talk about today, the judge was upset with the lawyers for several reasons. But the most important part, and the straw that broke the camel's back, was that photos of the crime scene of these 2 young girls who have been horrifically murdered were leaked to true crime social media outlets. So we are covering this and many, many other true crime and important legal cases. Be sure to hit the like button if you would for the video and subscribe. We'd love to have you back for more of our coverage. So the photos that I'm talking about were on the conference room table in the office of one of Richard Allen's lawyers, Andy Baldwin. A longtime friend and former employee of the attorney regularly came by to visit Mr. Baldwin, and he went into the conference room and took pictures of the photos and of the evidence. He was originally known as M, but we now know his full name is Mitch Westerman, and we know that because he's been arrested and charged with in connection with stealing these photographs. Now, according to the allegations, Mitch sent the photos to R, who sent them to Mark, who sent them to the Murder Sheet podcast. The regular case, the one that involves Richard Allen and the allegations that he murdered the 2 girls, was set for hearing October 19th, 2023. For the first time, the judge allowed TV cameras into the courtroom for that particular hearing. And the judge asked all of the lawyers to meet in her chambers before the hearing got started. So the prosecutors are there, the defense lawyers, the judge, and the court reporter. But those are the only people at it. In fact, even Richard Allen was not present at that meeting. Now, what happened in the meeting has been very controversial. We're going to read the key parts of it so you can see for yourself what happened. Until a transcript was released this past week, all anyone knew was that the judge came out in front of the TV cameras at the hearing when everyone was expecting some rulings on some really interesting, exciting, controversial motions. And she said that the hearing would be canceled, that the defendant, Richard Allen's lawyers, had resigned from the case, and that she would appoint new attorneys. It was a shock to everyone in the courtroom. But we now know a little bit more about what happened at the private meeting. That's what we're going to cover today. Within days of the time that she came out and made this announcement that the attorneys for Richard Allen had resigned, the defense lawyers started to say, no, we didn't. We didn't resign. We had a private meeting beforehand, and the judge more or less forced us out. She told us she was going to go into the courtroom in front of the TV cameras, read a statement about how grossly negligent and incompetent we were, and then fire us, or we could just quit. Our choice. So the defense lawyers called this public shaming and said it wasn't fair to them, especially since they had no notice. And Richard Allen wanted them to represent him, not some other lawyers. He wanted these lawyers in his case. Now, the defense lawyers decided to take their case to the Supreme Court of Indiana, filing a writ of mandamus. But the court reporter would not let the defense lawyers, Brad Rosie and Andy Baldwin, have the transcript of that meeting that had been in chambers saying, you're not on the case anymore. You know, the judge says you're not on the case. You don't get transcripts of cases and of hearings that are held privately if you're not an attorney of record in the case. So what we're going to do, but the Supreme Court, let me explain. The Supreme Court ordered that the transcript be released to them. They wanted to see it, and then it was made publicly available. That's how we're going to get to hear it today. Which side does it support? You're going to help me figure that out. I've chopped it down to shorten it a lot because it was really pretty long. It was frankly pretty concise too. I mean, they really were talking about this issue just about the whole time, but I've cut as much as I could down, and here's how we're going to do it. I've actually read this. There's no audio. It's literally a transcript. So I read it, and what I'm going to do is play a video of that. That way you can see in as big as possible the transcript. You'll be able to read along for yourself. And then it gives me a little break too, so I can comment, and it will break it up for you, I think. Instead of me reading and then speaking and reading and speaking, there's a little bit of a difference. So hopefully it'll be easier for us to go through. Let's get started. Rosie, it's probably obvious that the tension from our side is coming, from the words disqualification. And let me already interrupting. Mr. Rosie is one of the defense lawyers. So when you hear Mr. Rosie or Mr. Baldwin, when I say their name beforehand, that means they're the ones talking. If I say the judge, that means the judge is talking. There was also a prosecutor who spoke briefly, I think Mr. McClellan. That were murmured in the phone conference that we had a couple weeks ago. If I have a concern today, it's that, we're going to get out on kind of in the public, so to speak, in the courtroom, on the record, and have a discussion about an ongoing investigation. And that's what I kind of gathered from the email. I think you invited Nick to talk about that if you wanted to. It makes me a little uncomfortable because I don't know. First of all, there are no pleadings that are pending, whether they're motions to disqualify or contempt citations or whatever they might be, that really frame any of the issues. And I have no problem. I mean, I don't have any problem talking about this stuff privately on the record in an ex parte type confidential hearing. I just think it's difficult to expect that there will be any kind of structure to the idea of, hey, there's an ongoing investigation and just tell us what's going on. And I don't know that it has any relevance to what we're really trying to accomplish today. And so we're lawyers. We're used to having issues framed. We're used to having an opportunity to prepare. And I don't have anything to hide. And I know he doesn't have anything to hide. You've maybe gathered that we've cooperated. We ran into the state police posts, our respective posts, if you will. And I had somebody advise me of my rights, and I waived those, and I gave a formal statement. He did the same. So it starts off fairly casual, as if the lawyers are thinking, well, this may just be a matter of us responding to a presentation related to where the status of the investigation is, because we don't think we did anything wrong. So we, the defense lawyers, are thinking that the state may simply be going to inform the court, here's where we stand in trying to figure out who leaked these photographs. And they are about to find out. It is going to be way, way more intense than that. But they're already starting to hit the buttons that they're going to hit later. Things like due process. You normally, in a case like this, start with a motion. So where's the motion? Why are we here? Is this even related to the case? And you're going to see that the confusion increases as we keep going. Attorney Andrew Baldwin, I'm more of a, like, the due process side. I don't know what's going to happen, and I would like the opportunity to know what's going to happen and prepare for their claiming or whatever before it happens. I don't want to say ambush, but it's hard to know for me what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that, when Nick said, I don't know if he said the word disqualification, but the court, oh, he did. Mr. Baldwin, was it that word? The court, affirmative response. Mr. Baldwin, okay, I didn't know if he just said it in a more generic way. The court, negative response. Mr. Baldwin, and your response was, I'm leaning in that direction or something along those lines. The court, affirmative response. Mr. Baldwin, and so that's, a cause of concern. I mean, we're still wanting to try this case in January. And I'm willing to, we have made changes at my office that will prevent this from ever happening again. We're locking down every single thing on Delphi. It's in a dedicated room. We put locks on our conference room or the war room where this guy went. My friend went in and did this without my knowledge. And no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that can be something that the court, can say, all right, that's fine. And then let's get on with the trial. Oh, that is so not going to happen. That is what he would like. Just say, oh, okay, we got it. You're doing your best. You're going to fix these things. Let's keep moving toward trial. Not happening. And that is not what is going to happen here. I think the court's clipped responses are the clue as to how the court is already thinking. The attorney says, I don't know if he said the word disqualification. The court, oh, he did. I can just kind of hear the sound. I mean, obviously I can't truly hear the sound, but in my head, I hear him go, oh, yes, he said disqualification. And Mr. Baldwin, was it that word? The court, I can just hear it because I hear what happens later in the case. I don't know if it really sounded like that. But the defense counsel is actually thinking maybe the court will just say, let's all work together. Let's move toward trial. Let's forget this and put this in the past. In addition to the court's clipped responses, another huge clue for the defense was they've already been told by the judge to stop working on the case. They've been told that. And so and what's about to happen is not even close to, hey, let's just move forward. The court, anything, Nick? Mr. McClelland, this is the prosecutor. Judge, I guess my plan today was give the court a summary of the investigation. I've got witnesses here and exhibits to present that go towards the investigation. I'm more than happy to hand those over to defense. I know it may harm the investigation, but I think it would be important that the court hear these things. I'm concerned that the leak is not just a one-time leak. The evidence that we have shows it is an ongoing leak. I have an issue. What's next? I mean, I spent the past 17 days investigating this night and day when I should have been focused on preparing for trial. And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m. Mr. Rosie, this is starting to scream due process to me. I haven't seen any of these exhibits, and I don't know really. Frankly, I don't know anything about any of this. And I'm not distancing myself from Mr. Baldwin. I'm just saying I have no connection with any of these people. Okay. And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits and, testimony without us having any forewarning or any idea, any way of scrutinizing that seems a little outside the boundaries of due process to me. Plus, again, I get back to what is the relevance to what is going on in this case? Why are we going to use an open courtroom to air an ancillary matter? It's not really connected in any way at this point to the proceedings that are ongoing. Now, I want you to notice three things about what we just heard. The first is the prosecutor, and I don't know what name I gave him at the beginning, but McClellan was the correct name. But the prosecutor says they don't think it's just a one-time thing. They believe this is an ongoing leak. They suspect these attorneys on the defense side have been leaking other things, have been leaking things throughout. So this is a bigger concern for them. They aren't only focused on the photographs. The second thing I want you to notice is two really good points that are made by Mr. Rosie, one of the defense lawyers. The first is he says, this is starting to scream due process to me. And it is true. Normally, the way legal matters happen is there's a motion, something is set before the court, and then the other side knows what to respond to. They respond to that. Sometimes there's even a reply from the party that filed the very first motion. And there's an exchange of things like a witness list in advance, an exchange of discovery and documents. Everybody knows what's going to take place, or at least they have some idea. They have some boundaries around it. But here the prosecution has apparently an entire presentation and witnesses, and Mr. Rosie is saying he doesn't even know who they are. He doesn't even really know what they're going to be talking about, what exactly the subject matter is. And he's saying he feels very unprepared, like he's flying blind. He's also asking the question, how is this relevant to Richard Allen? He's saying, why are we doing this in open court before all of the cameras during a hearing about Richard Allen? Because this is really related to problems between attorneys and related to the leak and not related to Richard Allen, who has no possibility of leaking them. He's in jail right now. So now he's going to make a third point. And I will tell you this, and I'm prepared to show the court this, I would rather do it in private. This problem has been a problem from the very beginning, from our deposition that I took of Trooper Holman in this case. And in that deposition, he talks openly about how there were crime scene links from the very beginning. As soon as this crime occurred, they were investigating information that had been released because there were lay people that were part of the search party. And the implication is, and I've got the transcript, is that those people that found those girls started to essentially disseminate or distribute information. And law enforcement essentially try to catch up with them. But it was really too late, as you might expect. Once it gets in the hands of the public, it's too late. So he told us that, almost volunteered that information to me in the deposition. The second concern I have is that, I think I shared with the court just as an example, a week or two ago, somebody sends me a court TV, bit. And in that bit, Barbara McDonald is talking 2 different occasions. She mentioned how she's getting information from investigators on the ground that were at the crime scene. Now, we can all draw implications about that, but most importantly, it was corroborated by the fact that she was holding in her hand documents that I know to be directly related to the Purdue report. I mean, I saw the pictures. I know where those came from. His argument is, and this is Mr. Rosie, the defense counsel, one of the lawyers for Richard Allen, there have been a lot of leaks in this case. Leaks that came out way before we got involved in the case. And no one made a really huge deal about the others. This one is being treated differently from all the other leaks. And he's saying but he's also making a new allegation, pointing out something that the court TV reporter recently stated, apparently I haven't seen it, but recently stated that she was getting information from investigators on the ground at the crime scene. And he's saying, if that's happening, why are we focused on us? Why are we focused on the defense lawyers for Richard Allen? If the information was already out there, if there are multiple leaks, why is this one incident such a significant deal? And if you know, the point here is, I'm going to say this maybe a little loosely, but forgive me, I don't care. I don't care that all this stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time to sit and try to marshal all of this stuff while this case is ongoing because there's no end to it. But the point is the court needs to have some context that this is nothing new. I lost sleep over the fact that there's a man who's dead that I don't even know. And frankly, Andy doesn't know. And it's tragic. I don't know what circumstances he had or what surrounded this. What he's referring to is what I'm referred to or alluded to early on in the video. Remember, I said that M sent the photos to R, who sent them to Mark, who sent them to Anya and Kevin. In a twist that's so tragic, you would literally leave this out of your novel. If you were writing some crazy novel about these facts, which are already almost beyond believability in terms of a novel, but you would leave this part out. It would be too horrible. But apparently R was so devastated about the fallout from this leak that he died in a manner which can't be mentioned on YouTube, but involves self-inflicted and harm. Obviously, Mr. Rosie is saying this has taken a toll on everybody. And he's saying it took a toll on us as the attorneys too, to realize that this happens. Think about the judge too. This is not just related to the lawyers. All of these people are in a pressure cooker. The stakes are extraordinarily high. The scrutiny is enormous outside. And you can see that from the way the people inside this behave. M has been arrested. R no longer is alive. And would he have been arrested? We don't really know, but he obviously was emotionally affected by what had happened. But at the end of the day, what's going on out in the cyber world and in the public, as you might expect in a case of this magnitude that's been publicized for 6 years, was beyond our control before we even got involved. Mr. Baldwin, there's even a guy in Florida who says the guy in Texas who leaked all this stuff has received from a disgruntled Carroll County employee a whole file filled with stuff and photos included. If this could be set for a formal hearing in the future where we have a chance to do it the right way, then that's one thing. But, to go in there and we don't have any way to counteract anything. Honestly, this is the worst, lowest point of my career right now because somebody did what they did to me. And that has nothing to do with Richard Allen, the court. It certainly does not. Again, you can really tell from the way the court responds what direction she's headed. You can already tell that she is really upset. And you can often do this in a hearing. From the way the judge responds, from the things that are being said, what direction the judge is heading, how the judge is most probably going to rule. I don't think these attorneys have any idea what's about to hit them, but something is about to slam into them. And I think they're going to be surprised by that. But they can already tell that the judge is very upset. She is now about to explain why this hearing is taking place at all. The court. That brings us to my concerns that I raised with all of you on our phone call. And I write everything out. And this is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Mr. McClellan filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media. And less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. But it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. 18th of this year, you filed a notice of tort claim. All right, let's talk about what the judge is talking about. What we can see from this is long-standing. The court has been upset for a year. The court is not just upset about this one leak. To the court, this is an ongoing pattern of behavior. This is what it sounds to me like. Here's what happened based on what I hear the judge saying, that the prosecution came in and wanted a gag order. The defense said, well, there's really no need. We don't want to try this case in the media. And then issued a press release after the judge had not issued the gag order. I don't know if she had intended to and just hadn't done it yet, or if she bought the defense argument and decided, okay, I'm not going to issue a gag order. There's no need for one. but she felt tricked. She felt like she followed up with a gag order, but by then it was late because there'd already been this press release. And so she was upset. Now, you know, from what I've been saying on the channel for quite some time, that I think it's very unfair for the prosecution to be able to go out and file the initial documents and put out in the public their theory of the case and the facts they believe support them, and for the defense not to be allowed to give a public response. I think it's unfair for the prosecution to go in with this huge dump of information all on their side, and then that's when the gag orders slam into place, and that's when there's no more talking to the media. I don't think that's fair. I think the defendant needs to have the chance to respond, if the defendant wants to, in a way, because of the social media influence and because of how important that is, how powerful it is in our society. I do think it's unfair, fundamentally unjust, if the defendant doesn't get a chance to also speak into that forum. That is part of what today's forum is. It's not just a courtroom anymore. Now, so I don't know what was said in that initial hearing. I do think that if for any reason Mr. Rosie, Mr. Baldwin agreed, yes, we will not go to the press or media. I personally don't think they should have made that agreement, but I'm not sure that they actually made that agreement. I just want you to kind of hear what the judge is saying and why the judge is upset. Now we're going to hear a little more about that tort claim. 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. I'm about to say May of this year, but that really leads into the next part. So I think that what she's saying is that, and what the attorneys are going to be talking about here, these are court-appointed attorneys to represent a defendant who can't afford to pay. So they're being paid by the state. The state is picking up the bill for Richard Allen's defense. And she's saying it's inappropriate for you to use that appointment where you've been appointed and given this special privilege of representing him for pay by the state to get yourself a paying contingency fee client. You can't use it that way. I don't know for sure whether that is the rule or not. I do know that you, in a tort claim against the Department of Corrections or any state or sometimes county, city entities, you often do have to give an ante litem notice. That's a notice that you give in advance telling them we're about to file this case. We think we have this case. And if you don't give the notice, and it's not as long as the normal statute of limitations, if you don't give that notice, you cannot file. You can't file your case. So what they're going to say through, and I don't know if I included this clip, but their response is going to be, look, somebody had to file this notice of tort claim for him so that he would have a chance to bring a case. That doesn't necessarily mean we're going to take the case, but somebody needed to file this. This year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product. And I think it was an outline that you created for yourselves with the discovery. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court. It wasn't shared with you, although apparently you guys knew about what was going on. Mr. Baldwin, he didn't know. The court, you knew. Mr. Baldwin, I did know. The court. So then Mr. Woodhouse gets arrested, and here we are. Grossly negligent to email that to the wrong Brad. Your pleadings on the safekeeping order contain inaccuracies and falsehoods. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. And then the last couple of weeks, let me stop it quick. So apparently, Attorney Baldwin sent an email to the wrong person. I'm sure we've all done that at some time or another, but in this case, he sent it to the wrong Brandon, and it created a huge mess. He disclosed evidence that should have been under seal. And as a result, some of the, I know from watching a YouTube video by Brandon himself that he felt like he was being set up by Attorney Baldwin. But the YouTube video by Brandon describes a lot of information. This kind of talks about an outline of discovery as opposed to a large amount of information. The court clearly thinks that Baldwin lied about it and that the state proved that. That's what the court believes happened. That's what's in the court's understanding. I do not know the details on it, but I want you, and this is sort of an answer. I've seen Annie's question floating through the chat about, are these attorneys being set up? I think you have to see it in the context. I want you to sort of understand from both sides what the judge is really upset about, and then make and sort of understand then why it is that the defense lawyers think she went overboard and went too far. So we'll keep going, but I've got your question in mind. I think it's the important question that we've been dealing with. The state provided you discovery that has been severely compromised. We now have an ongoing investigation. I'm not going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You've had an attorney enter a written appearance this morning. I'm glad to hear that you have cooperated. But Mr. Baldwin's attorney included the fact that you left materials all over a conference room table, accessible to anyone. And this is a friend of yours who apparently you have consulted with on this case. I was about to say the word case. I cut myself off there. So this is the big and the new matter that we've been talking about. There were photos taken of the documents and photos of the crime scene that were released, as we talked about, not by Baldwin, not by the attorney for Richard Allen himself, but by someone he knew. It would be, I think the judge's comment that this was accessible to anyone, I think that was a little broad. I don't think that's quite fair to say it was accessible to anyone. It was, after all, in his conference room, in his law office, and I assume when they leave, they lock the door. But it was apparently accessible to this friend who used to work for Baldwin, but no longer did. To the court, I think this is the straw that broke the camel's back. And I think it would be safe to say that in the court's mind, this was more of what the defense was doing, which was intentionally leaking selected things. I think that's what the court would believe. We have not heard from the court yet, but I think that's where she's going to go. We, in fact, should be seeing her response on Monday. Case. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. I am gravely concerned about his rights to have competent, non-negligent representation. He currently doesn't have that right now because what you have demonstrated is negligence and incompetence. Remember, she is reading what she plans to read in open court in front of TV cameras. And she's going to say that she believes they are negligent, grossly negligent, that she believes they are incompetent or have behaved incompetently here. It is extraordinarily harsh. I mean, I want you to kind of picture what it would be like from the attorney's perspective to have that read in open court. Really, really, really serious, as you can imagine. And we're going to hear them talk about it now. Now, I am sharing my thoughts with you privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case, but I will. But you don't know that. You have just now been made aware of my concerns and where I'm landing. So if you wish to have a private conversation, I would encourage you to do that. Mr. Rosie, I mean, obviously reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will, if that's the right term. Is there a scenario where the court would accept if I stayed in the case? I mean, I'm a team player, and I'm not the kind of guy that just bails out on somebody just for the sake of doing it. I'm not as connected to some of, this most recent circumstances as he is. Mr. Allen is in a situation where he's going to have counsel that's, if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter. Is that an option that the court would entertain? The court, no. So you can, oh, I did it the opposite way that time. Sorry about that. So Rosie has a really good point. These incidents seem to involve Alec Baldwin, and he's saying, why am I having these things read about me? Why am I being kicked out of the case? And he's drawing the court back to the issue of Richard Allen, because Richard Allen has a constitutional right to a speedy trial. And he's saying he's not going to get that, because what's going to happen is a year-long wait while new counsel come up to speed. Why are we doing this? That's Rosie's point. But the court clearly is unswayed. Just a quick no. The court is not even remotely thinking about this. Mr. Rosie. So basically what you're saying is you guys either quit on your own accord or you make me fire you. The court, no. I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Mr. Rosie. Well, so Art, is this the culmination of that you're removing us from the case? The court, I will, based on what I've just shared with you. I don't want to do this, but I will. So I personally, the judge won't agree with them that she's saying quit or I'll fire you, but I read it that way. I think that is what she's saying. And furthermore, that she's going to fire them in a very embarrassing way, publicly, with statements about what a poor job they've done and how they're incompetent and grossly negligent. The court doubles down on this. The court gives them, though, a chance to think about this and decide what they want to do. They go out into the hall, talk to their client about it, because remember, the client's not here at this conference. The client has no idea this is happening. They come back and Rosie delivers quite the speech. Will, if I have to. Mr. Rosie, our client is a big part of this, the biggest part of this, and he has communicated to us that he does not want us to withdraw from this case. He would like to say that on the record. I'm going to file a motion to withdraw. I don't want to do it, but I don't think they have a choice at this point. The options I've been given without any notice by the court really are either I withdraw or I'm going to be publicly shamed. And I think that public shaming is not only, there's not only a professional element to that. I think there's a personal aspect to that too. But when the media is teed up like this, and we show up here today with the court having told us that we were going to conduct some business, that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, that, I don't feel like I have any other choice professionally. I have a life beyond this courtroom and beyond this case, and I have a family too, and I have a law practice. If this would have been framed in a pleading format or some formal disciplinary claim, which there's a process for that in our business, then we could have come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here. And we didn't have that opportunity. And it's the idea that I'm going to have to go in here in an open courtroom and essentially defend myself against claims that I don't agree with without any notice and without any opportunity, I think is unfair. But I also have some common sense. And, me going in there and standing my ground because my client wants me to is just going to make things worse for him. And so I'm going to withdraw my appearance. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and have them prepare a motion. And I'm going to withdraw my appearance. But I'm doing it because I don't think I have any other choice professionally, not because I want to, and not because my client wants me to. Wow. That was quite the speech, and on the spur of the moment, because he did not have notice. It was really well done. And he's stating affirmatively the client does not want them to resign. Richard Allen wants these lawyers to represent him. He doesn't want to resign. He wants to stay in the case, but he feels like he's being forced to make a choice for his family, for his other clients, for his law practice, for the people who work with him. But he wants to add, he doesn't think this is the right process. He hasn't had the chance to respond. So I saw S. Cypher's question about, is this going to affect the lawyers for future cases? You bet. No matter what way it came out, it would. If there had been a reading in open court where a judge said, I believe you to be, as she said, grossly negligent and incompetent, that's certainly going to cause people to think twice before they hire these lawyers, right? So that was one of the things that the lawyers were thinking about. And Rosie says, I've got to practice. I've got a life beyond this case. I have to think big picture. Mr. Rosie. And, I am extremely, I'd say frustrated is probably a soft word with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think it's improper. The court. Well, I think we talked about it. When you asked for a disqualification, and I indicated on our phone conversation, I'm inclined to do that. Mr. Rosie, it was a phone conversation that was not on the record and then some follow-up emails. The court, true. Mr. Rosie, there's an informality to that. The court, true. Mr. Rosie, and you also said that you hadn't even done any research and you hadn't, had time to talk to your senior judge and all these other things. And he hasn't filed a pleading with the court either. The court, no, I'm doing this on my motion. So there are several important things I want you to pull from what we just heard. First of all, the court said that she was inclined to do this, and she said that before the hearing. Now, that certainly was an important clue that Baldwin and Rosie both should have been thinking closely about. There were also apparently emails. We aren't privy to what those were, but there were emails that discussed the concept of maybe disqualifying the attorney. So it wasn't completely a surprise. But Rosie says, and the court agrees, that that was pretty informal and that the court had some more things she wanted to do. So clearly Baldwin and Rosie thought they had more time and that this would be a little bit more formal, not just a sudden, today you're out. And clearly the attorneys weren't expecting it that fast. Also, the court also noticed that the court says this is on her motion. The prosecutor hasn't asked for this. The judge is doing this on her own motion because she believes it's what should happen. Mr. Rosie, in 20 years, I've never had a disciplinary complaint in my life that's been confirmed, if you will. But I've seen lawyers disqualified, and there's a process for that. And it's not this, with all due respect, where you walk into somebody's office, a judge's office, and they read a prepared statement to you. And essentially that statement is an indictment on my professional, activities. And then you're handed essentially a sheet of paper, two options. And one of them is, I'm going to go out here and shame you, or you can quit. You can understand how upset that would make any lawyer. And I just think I don't think it's the right way to handle this from a due process standpoint. So I have no choice. Mr. Baldwin, I'm the same, withdrawing. I mirror what he said. I mean, I do appreciate giving us the advance notice. If there is some appreciation for that, I do appreciate that. I wanted to take this and finish it out. I'm stunned. I don't know what to say. So I'll just say I'm moving to withdraw orally. And we will stop there. Let me pull that out. And I'll take a look at what some of your questions are over in the chat. I am curious. What do you think? Did they resign voluntarily? Or do you think they were forced out? And I would say there's probably a clear and definite no on whether they resigned voluntarily, but the court, I think, is going to say ultimately they did in fact resign, they withdrew, and so I was entitled to name someone else. I want you to also understand the frustration level of the court in what she saw as repeated violations. But it is hard for me to understand why that extended to Rosie, since it did seem like he wasn't involved in those same things. So it did seem to me like he was separate, and like most of the things that she read out as being concerns of hers related to Baldwin and his office. And how much of those were actually were serious, I don't know. What we do know is that now the defense team has asked the Supreme Court to kick the judge off the case. And it's not just the defense team. The public defenders have come in too and supported several of the things, maybe not all, but several of the things that the defense has requested, saying it was improper for the court to just appoint new counsel of her own accord. There's a process for that. You can't just appoint anybody the judge wants to, and come in and supported the idea that these lawyers should have been given an opportunity and a chance to defend themselves. So I am really curious. Please put that in the chat. What are you thinking? What do you think about this? We also will cover, when we get that response from Judge Gull, we'll cover what she says. What is her explanation? There has been a story recently about how, I believe it was on the 2nd, she went out ill or was even hospitalized for several days and has been working from home and has been ill. So it's also possible that she will withdraw from the case for health reasons, and that the issue will be taken off the table. It might even be something that would just be an easy way to handle the matter for everyone involved if that's what ends up happening. But I am curious what you think. So be sure to put that in the chat or in the comments if you're watching afterwards. Let's see. Annie is asking me, what would the judge's reason be to force them to recuse themselves since social media and protecting information is impossible these days? I strongly agree with that. I don't think it's appropriate. If someone is repeatedly violating the judge's orders, the judge is trying to keep some control on things. And I will say, disseminating pictures of young girls who have been murdered is pretty disgusting. That's really bad. But on the other hand, there is an absolute right and need for them to defend their client and for them to approach social media. I felt like they sort of split that baby with their brief. They didn't file photographs, but they described some of the facts that made them believe this couldn't have been done by one person, and that it was very ritualistic, that it was related to a ceremony, not something that Richard Allen just would have done on a random weekday afternoon. So I think that the judge's reason to force, I don't think that the judge, in my view, should have forced them to recuse themselves. But I think that we can see from what was said in the hearing that there were a lot of facts along the way that led up to this, not just a single event. If it had been only the photographs, I think that would be a clear, it's not their fault. Someone came in and took photographs in the conference room. We don't get lawyers off for that. But so I think that's not what it's about. I think the judge had several different things. So we will find out more about that when she files her brief. I do think these lawyers had done a remarkable job for Richard Allen. That brief that they filed was very unusual in its breadth and how much detail there was, their command of the evidence. Did I agree with all of it? No, probably not. But I respect it a lot because it was so much work and because they were doing it, I think, to protect their client. So, but yes, it's literally impossible to protect fully things, but there are rules. And if someone violates the rules set out by the court has to take action. In this case, it doesn't sound like there were super clear violations, and certainly not this final one, since it wasn't directly related to these attorneys, or at least anything they've done. I think leaving pictures out in your conference room, every lawyer does that. You have a war room, and the war room is where you spread out all your stuff when you're preparing for trial. That's what you call it, a war room. And you leave, and the whole point of it is that you spread everything out and you leave it there so that you don't have to do that every time. This is not like, IBM where they put everything away and it has to be locked away. These are private law offices, and they lock the door when they leave in the afternoon. So I don't think there's anything surprising about having a war room. And to me, I've seen many a war room. I've had many a war room, and I've left my stuff out because that's what you do. So let's see if there are any more questions or if there's anything more I can answer for people. Look, it was so clear. I don't think y'all had too many. I don't think y'all had too many questions. This is good. Well, I mean, I like your questions too, but I'm glad that it was clear. So Monday, we'll get that response from Judge Gull, and we will talk about that. Maybe not Monday. Monday is also the Murdaugh sentencing. We're going to be hearing from victims. So be sure to subscribe. We have so much going on. It is a blast. You really don't want to miss this. If you would, please hit the like button. That'll really help the video get out to more people. I want to thank Marlon, who helped us with this extra live, even on a Saturday. Thank you for doing that. And thank you all for coming. And I will see you Monday at 7 p.m. Eastern. And one more video is probably going to drop this weekend. Don't miss that either.